Hello everyone, welcome to Times Trial. This is Advocate Preeti Acharji.
So today we'll see Administrative Law Module 2 Delegate Legislation Part 1. So let's see the module content. So here it will start with the reason for growth of delegate legislation is constitutional validity, forms and types, restraint on delegate legislation, comparative position with UK, USA and India, doctrine of excessive delegation, powers of exclusion and inclusion and power to modify statutes, safeguards and control on delegate legislation, legislative, judicial and other controls, sub-delegation of legislative power. So here we'll first see the first 1 to 5 more topics, and the other 3 will be on the next part. So this potential question you can see which can come from this module. So specifically the important part of the module is covered. So here we'll start with the first, that is on delegate legislation. Here we'll combine the first topics, that is your reasons, then constitutional validity, forms and type, restraint and the comparative position. So this constitutional validity, restraint, that can separately also be asked, so you can follow the same synopsis and omit one or two, which the concept which is asked in a question paper you can elaborate it on that part specifically, and the other you can just write for increasing the length of your answers in short. So let's start with the introduction. So you will see introduction and historical background of delegate legislation. So you can say that lawmaking has become a primary function of the legislature in a democracy. Now, increasing complexity in governance make it hard for legislature to draft laws on every detail, and so this sort of delegate legislation, it refers to law made by subordinate authorities under powers granted by the legislature, which is also known as subordinate legislation, secondary legislation or executive legislation. It lays down the policy and framework while authorities implement the technical and operational details. So the originated and grew significantly in the UK, which was especially during the war time for administrative efficiency. Now in India, the delegate legislation was adopted during the British rule and expanded post-independence of development. So after the independence, the workload has become vast. The legislature alone was impossible to handle each and every sector. So it was impossible for legislature to every time review the condition of the state, local authority workings. So it was impossible for the legislature to make laws in each and everything, which would have led the legislature to only focus on drafting the laws. So because of this prospect, the delegate legislation concept was being introduced, where the legislature will give power to the local authorities or the subordinate or the state subordinate to make the laws or any sort of statute or notification as per the requirement of the state. Now, as we have previously discussed, the simple meaning of delegate legislation is that when rules and regulation or notification orders or bylaws are made by the subordinate authority under the authority of the parent act passed by the legislature, this sort of power is called as delegate legislation. So here the local authorities are given the power by the legislature to make subordinate laws, notifications, bylaws under the parent act which has been passed by the legislature. It is also referred to as secondary legislation or subordinate legislation. Now there are some of the definition by renowned writers. You can remember it. Sir Ivar Jennings, who said that delegated legislation is a law made by an executive authority under the power granted by the legislature. As we have discussed, that it is a power given to the executive to make laws under the power given by legislature, and it is essentially for filing the technical and procedural details left by the primary legislation. Then there is S.P. Sate, who is an Indian jurist. His interpretation that it is a law-making power given to the subordinate body by the legislature to deal with the technical, administrative or specialized matter which are beyond the competence of the legislature to handle directly. Then H.W.R. Wade, who is in constitutional law scholar, he has also been defined delegate legislation. So you can remember these points. Now we'll see this concept with an example. Now suppose consider there is a new law passed by the parliament regarding environment protection. Now this law sets the broad objectives such as reducing air pollution, protection forests, and promoting the sustainable development. However, the law does not go into the specific details like how much air pollution is acceptable, the exact procedure for checking pollution levels, or what penalties will be imposed or violators. So to fulfill these technical details and make the law practical, Parliament grant delegate authority to the Ministry of Environment. So this ministry then issue regulations such as specific air quality standards for different regions, penalties for exceeding pollution limit, procedure for companies to report their emission. So in this case, the Ministry of Environment is using delegate legislation to make the rules that fills the gap left in the Environment Protection Act based by the Parliament. So now let's quickly see the reason for growth of delegate legislation, that what has led to the growth for delegate legislation. So the first one is complexity of modern governments requiring technical expert. Now suppose there is an environment law, tax law, and health regulation often require detailed scientific, economic, and technical knowledge to be effectively implemented. Now, if the legislature typically made up the generalized rather than expert in every field, cannot be expected to draft detailed and specialized regulation for every emerging issues. Now, as such, delegate legislation allows specialized agency or department to fill in the technical details and ensure the law is both relevant and enforceable. So this complexity of each and every situation has also emerged the need for a delegate legislation. Now there is limited time and resource of legislature. So as we know, the legislature is already overburdened to see other sector as well. So the time limit and the resources are abruptly limited, so they cannot dedicate themselves totally on drafting, like every small detail of every law cannot be assessed by them. So there are thousands of issues that are required legal regulation, but legislature have limited capacity to address all of them directly. Suppose in parliament system like that of India or the UK, the legislature might only meet a few times a year and may be preoccupied with broader policies, debates, or urgent national issues. So this delegate legislation become essential to handle the nitty-gritty details of laws without consuming the legislature limited time, and parliament can pass a general framework and then delegate the task of specifying the operational details to the executive branch or relevant regulatory bodies. Now the emerging situations. Now suppose there is a quick need of lawmaking. So this emergency situation also helps. And there is a delegated legislation who can emergently make a notification. Suppose during the emergency period or natural disaster like the COVID period, so there were many notification that we have seen that has been passed. So it is impossible for the legislature directly to pass such notification, because every state has specific requirement or specific restriction is needed to be imposed on those area. So through delegated legislation, it allows authority to issue emergency orders, ensuring quick and timely response without waiting for prolonged legislative procedures. Now we'll see flexibility. Now law needs frequent updates. Parliament cannot amend frequently. So another critical reason for the growth of delegate legislation is the need for flexibility. Many laws passed by parliament or similar legislative bodies provide a broad policy framework but cannot easily anticipate future development for changing circumstances. Like for example, tax law, environmental legislation, or financial regulations require constant updates to keep up with the changing market advancement or evolving public needs. So parliament cannot convey frequently enough to pass the amendment for each change. So this delegate legislation allows these laws to be updated without lengthy process of introducing a new law. Regulatory bodies, once empowered by the parent act, can make periodic adjustment to existing rules and regulation, ensuring in the law stays relevant and effective over time. Now detailed implementation. So statute provide framework, details are delegated. So in many cases, primary legislation provides a broad principle and objectives, but it lacks the necessary detail required for its practical implementation. So this practical true for law that involve administrative procedure, technical, local consideration. So for example, land acquisition laws may lay down the framework for acquiring land for public projects, but leave the details such as valuation, compensation, process of appeal to delegate authorities, so that the delegate legislation can fill in these gaps, providing the necessary rules and guidelines for the efficient functioning of the laws. Now there is experimentation. Now it helps in testing scheme through delegate provision. Now delegate legislation also provides an opportunity for experiment with new policies or scheme before they are fully implemented across the board. Now it allows pilot project or test regulation to be put in place, which can be modified or improved based on the practical feedback. Now for example, a government might pass a parent act authorizing the implementation of a new educational reform, but delegate the responsibility for implementing the reform to a specific body. Now the body could then carry out a pilot program in certain region or school. Based on the result or feedback from this experiment, the government can decide whether to expand the scheme or make necessary adjustment. Now let's see constitutional validity of delegate legislation. So in India, the constitutional validity of delegate legislation is crucial, as it involves the delegate of legislative power by the parliament to the executive or other subordinates. Now Indian constitution does not expressly deal with delegate legislation, but permits delegation in specific circumstances. Now this validity of delegate legislation in India is assessed based on its alignment to the constitutional principle and judicial pronouncement. So delegation of legislative power under the Constitution. So the Constitution of India under Article 245 grants the Parliament the power to make laws for the entire country and state legislature the power to make laws for the respective state. Now this Constitution does not expressly prohibit the delegation of legislative power as long as it adheres with the certain guidelines and principles. Then Article 246, which defines the distribution of legislative power between the union and the state legislation. However, this article does not limit the delegation of legislative power to the executive as long as certain constraints are observed. Now, Doctrine of Separation of Power. One of the fundamental principles of Indian Constitution is the Doctrine of Separation of Power, which divides authorities among the legislature, executive and judiciary. Though the Indian Constitution does not explicitly state the legislature cannot delegate its power, it requires the essential legislative function remains with the legislature. The Supreme Court of India has upheld that delegate legislation does not violate the doctrine of separation of power, provided that essential legislative functions are retained by the legislature, delegation is made in a reasonable and controlled manner, and the executive is not empowered to make substantive law but only regulation, rules or details within the scope of the parent statute. So whatever modification is done or the law is been bring, it has to be within the ambit of the parent statute. Now there are case laws like MCKC Gajapati Narayan Dio versus State of Odisha, with a focus on the delegation of power while retaining policy determination with the legislature. Then there is Indian Express newspaper, which deals with the validity of delegate legislation, affirming that it must adhere to the policy of the parent statute. So these are 4 of the case laws that you can mention. Now the limit on delegate legislation. The Supreme Court has established certain principle to guide the limit within the delegate legislation. So firstly, the parent act must lay down the policy framework. So whatever policy that has to be introduced, the parent legislature must be followed, or the parent legislature must have the provision so that any statutory laws can be or any regulation can be impact. Now the case law with an example we can see is in Manara Mills versus Union of India, where the Supreme Court emphasized that for the validity of delegate legislation, the parent act must lay down a framework of policy, and any delegation without the same could be deemed as unconstitutional for lack of legislative control. Second is no delegate of essential legislative function. So you cannot delegate any essential legislative function such as determining the substance of the law or altering the framework of the parent act. Now the case law is MSKC Gajapati Narayan versus State of Odisha. where it was stated that the essential function cannot be transferred and the power to make rules and regulation must be within the scope of the parent act. Then there is delegate legislation should not be arbitrary or discriminatory. Now this cannot be arbitrary, discriminatory or beyond the power conferred by the parent statute. The rules made by the executive must reflect the legislative intent and not violate the basic structure of the parent statute. Now this case law is Harish Chandra versus Union of India. Then there is judicial review of delegate legislation. So while delegate legislation is made by the executive, it is still subjected to judicial review by the Supreme Court or High Courts. The Supreme Court and High Court of India have the authority to scrutinize whether delegation legislation is within the scope of the power granted by the Parent Act, whether it is consistent with the Constitution and fundamental rights, whether is it not arbitrary or discriminatory. Now, if delegate legislation exceeds the authority granted by the Parent Act or violates constitutional principle, it can be struck down by the judiciary. Now, in state of Rajasthan versus Union of India, the Supreme Court held the judicial review of delegate legislation is permissible to ensure that it is in accordance with the parent statute and does not exceed the legislative intent. Now, role of Parliament and safeguard. Although the executive is delegate power to make regulation or rules under the Parent Act, Parliament retains control over the delegate legislation. It can ensure the delegate rules and regulations are in line with the parent statute through laying down of rules before Parliament for scrutiny, providing for parliamentary oversight via affirmative or negative resolution. This ensures that the executive does not exercise unlimited power and provides an opportunity for legislative control over the delegate laws. Constitutional amendment and delegate legislation. Constitutional amendment can impact the delegate of legislative powers, allowing for specific delegation to be made to the executive. However, any constitutional changes must still adhere to the basic structure, doctrine as established by the Supreme Court, and it means that any delegation of power cannot alter the basic structure of the Constitution. So these are the important case laws that you can write down, which talks about that sub-delegations. Then there is delegation is allowed if adequate policy and guidelines are taken. It is valid if Parliament cannot dedicate at essential legislative functions. So these are some of the case laws that you can remember. Now the forms of delegate legislation. What types of delegate legislation are there? Firstly, statutory instrument. Now, statutory instruments are rules and regulations which are made by the authority under the power granted by an act or. Now, these are used for filling in details of an act or make technical changes that do not require full legislative debate, like the Central Motor Vehicle Rules made under the Motor Vehicle Act 1988 in India outline specific vehicle standards, registration procedures and penalties. Then there are bylaws. Bylaws are laws which or regulation enacted by the local authorities, corporation or other designated body for the governance of the local issues. So a municipal corporation in a city may create bylaws to regulate waste management, noise control or zoning laws within its jurisdiction. Then there are rules and regulations. Rules and regulations are framed by ministers and department to give effect to the provision of the act. For example, the Factories Act in India had various rules regulations issued by the Ministry of Labor and Employment to regulate factory conditions, health standards and work safety. Then there are orders and notifications. So order and notification are issued by the executive or other authorities to manage administrative process or make changes to the existing laws, often without the need for full legislative process. So these are usually used for immediate implementation or procedure adjustment. So for example, a government notification declaring a new public holiday or an order issued by the Ministry of Finance adjusting tax rates for a specific year. Then there is Henry VIII clause. So this clause enables the executive to modify, amend or even repeal primary legislation without the need for a full parliamentary procedure. So they are often controversial and used sparingly due to the concerns over the concentration of powers in the hand of executive. Now, for example, the European Communities Act 1972 in the UK include a Henry clause which allowed for the government to amend or repeal Act of Parliament to give effect to the European Union laws. Now, conditional legislation. Now, conditional legislation is a type of law that becomes operative only upon the fulfillment of specific condition or event. Suppose a law that grants tax rebates only if certain criteria like investment in renewable energies are met within a specified time frame. Then there is sub-delegation legislation. Now this occurs when delegate who has been granted legislative power further delegates this power to another authority or individual. However, this type of delegation requires explicit permission from the original legislature. So a government department, suppose a Ministry of Finance, may delegate its power to Securities and Exchange Board of India to frame specific rules and regulation of stock market, but this delegation is contingent upon approval from the central government or parliament. So the restraints on delegation of legislative power in India, UK and USA. So in India, the delegate of legislative power is generally allowed, but there are certain restraints to ensure that the core legislative function remain within the purview of the legislature. The Article 245 of Indian Constitution allows the Parliament and state legislature to make laws, but there are limitations. Suppose the doctrine of excessive delegation. So as established in judicial pronouncements such as the Delhi Law Act case, exercise delegation is prohibited. Now the Indian judiciary insists that the legislature cannot delegate its essential legislative function to the executive without laying down clear guidelines. Then there are Article 248 and the residuary powers, where the Parliament has the power to make laws under the Article 248 that specify a union or state laws. So this power cannot be delegated in a manner that alters the structure of the essence of the Constitution. Now subordinate legislation. The delegation of power to make rules and regulation is valid provided that there are sufficient guidelines or standards within the parent law. Now landmark cases KK Verma versus Union of India. So for delegate legislation, KK Verma and Union of India is the most important case which you can cite specifically on many of the topics as we have seen previously. So we'll see what about UK. So in UK, the doctrine of parliamentary sovereignty is paramount, meaning that the parliament can delegate its legislative power if it chooses to. However, there are sufficient restraint and norms. So parliamentary sovereignty. The UK does not have codified constitution. So parliament theoretically has the right to delegate any legislative function. However, parliament usually delegates power with clear and definite limits. But there are limits on delegation in UK. The UK has developed legal principle to control the delegation of power. For instance, suppose an legislative delegation to the executive must not be allowed to the executive to amend the law itself, but only to fill in the details, like also the Henry VIII clause that we have seen, which has to scrutinize to ensure they do not undermine the principle of parliamentary sovereignty. Then there is judicial review. Courts in the UK has the authority to review if the delegation of power is appropriate. Excessive delegation which undermines the legislative role can be challenged. Now we'll see the situation in US. So in US, the delegation of legislative power is governed by the non-delegation doctrine, a judicial principle that determines the extent to which Congress can delegate its legislative authority to the executive or administrative agency. Now, non-delegation doctrine. This doctrine, derived from the Constitution, holds the Congress cannot delegate its legislative power to the executive branch without providing an intelligible principle to guide the exercise of the power. Now, the court have generally allowed delegation, but with limits. There are case laws also of US, that is J.W. Hampton, where the Supreme Court ruled that Congress can delegate power to the executive as long as it provides clear guidelines. Then there is another case is Mistreat versus US. Now there is a restraint on delegation in USA. The principle of checks and balance ensures that while Congress can delegate powers to the regulatory agency, it cannot surrender its core legislative function. So agencies are required to act within the scope of authority granted by, and the court can strike down over broad delegations. Now we will see the comparative constitutional position. Now, while India allows the delegation of legislative power to the executive, it stressed the need for guideline and restriction to prevent the excessive delegation. Now, court maintains supervisory role to ensure the delegation does not infringe upon essential legislative function. Whereas in UK, the parliamentary sovereignty is the cornerstone of the UK law, and Parliament has the extensive power to delegate its legislative function. However, there are still limits, particularly regarding the power of excessive and the preservation of parliamentary supremacy. Then in USA, the US Constitution imposed the most expressive restraint through the non-delegation doctrine, which requiring that any delegation to the excessive be based on the intelligible principle. So the judiciary plays here a critical role to determine the limit of such delegation to ensure the separation of power. Hence, while India, the UK, and USA allow some form of legislative delegation, each country has different mechanism and judicial safeguard to ensure that the core legislative functions are not unduly transferred to the executive. India and the USA are more likely to engage in judicial scrutiny of such delegation, whereas the UK relies heavily on the parliamentary discretion. So you can make a chart comparing both India, UK, and USA on different points like permissibility, like India allowed with limitation, broad due to parliamentary sovereignty in UK. Then in US it is permitted but strict, monitored under non-delegation doctrine. Then we have the judicial review. Then there is important case laws, doctrine used. So in India, doctrine of excessive delegation is used. In UK, parliamentary sovereignty doctrine is used, and in USA, non-delegation doctrine is used. Then there is a control mechanism. Now in India, legislative, judicial, and executive oversight, whereas in UK it is parliamentary communities. Then in USA it is congressional review, and then judicial scrutiny. So in this answer this are all. You can then end up with a short conclusion about what is delegate legislation and what we have talked about the constitutional validity, then on the restraints and the forms. So the next thing we are going to see, as we have previously seen in the first question about doctrine of excessive delegation. So now we'll have an explicit discussion on the specific topic, doctrine of excessive delegation. So this is the synopsis. You can start with an introduction, meaning of excessive delegation, doctrine of excessive delegation, nature and scope, test applied by the court in excessive delegation challenge, excessive delegation in Indian context, importance of the doctrine, advantages, disadvantages, and then we'll end up with a conclusion. Now let's first start with the introduction. So this doctrine is a constitutional principle that limits the extent to which a legislative body can delegate its power to the executive or authorities. It is specifically based on the fundamental idea that legislature as the representative of the people must restrain its essential function of lawmaking. Now delegation becomes problematic when it transfers the core legislative function to the executive or other bodies without sufficient guideline, control or check, which can result to erosion of the legislative power, undermining democratic governance and the separation of power. Now in short, it is while some degree of delegation is permissible for practical purposes, the doctrine of excessive delegation posits that any delegation beyond certain boundaries violates the principle of separation of power under Indian Constitution, which says that each of the part like legislative, executive and judiciary have specific powers cited under the Constitution, and this democratic structure of the state cannot be changed. So in a constitutional democracy, that this doctrine of excessive delegation ensures that the legislature does not abdicate its core duties and responsibility to other branches of government. Now we'll understand excessive delegation. Now excessive delegation occurs when the legislature delegates its power to make laws or enforce laws without providing clear and reasonable standard or guidelines. Now this type of delegation undermines the legislative authority and leads to an imbalance of distribution of power between the legislative and the executive and the judiciary as well. Now, court usually steps in to ensure that any such delegation does not violate the constitutional fundamental principle. Now, as we have said before, that the doctrine of excessive delegation, it ensures that the principle that the legislature, while it delegates its power to the executive or other bodies, should not transfer its core or essential legislative function to the executive in order to ensure that the basic structure and the doctrine for separation of power under the Indian Constitution is safeguarded. Now, key concept of the doctrine. So the first topic that we have seen, that is separation of power should not be harmed. That has three of the branches of specific power, so it should not conflict with this separation of power. Now the second key concept we have seen is limit to delegation. Doctrine of excessive delegation, it shows what sort of limit can be imposed to the delegation. Then there are guidelines and standards. Now when delegation occurs, it must accompanied by clear guidelines from the legislature. The law must provide clear standard, criteria and principle for the executive to follow while making any order or any rules and regulations under these powers. Then there are essential legislative function, which refers to tasks such as formulating the policy of a statute, defining key rights and duties, and deciding the broad principles of law. So you can also refer to this example. Now suppose if a country Y Parliament passes a law that empowers the Ministry of Health to regulate the pricing of medicine. However, the law is vague, stating only that the ministry should set reasonable prices for medicine based on market condition without any specific criteria or limit. Now a pharmaceutical company like Pharmaco challenges the law, arguing that it is an example of excessive delegation because Parliament has granted the ministry too much discretion without clear guidelines or on how to set the prices. Now here the court can agree with the Pharmaco ruling that Parliament cannot delegate its lawmaking power to the ministry in such an open-ended manner. Now the court may hold that the law is unconstitutional because it lacks specific guidelines allowing the ministry to act arbitrarily. So the nature of doctrine of excessive delegation, that it has a limit on legislative delegation, it upholds the separation of power principle, it prevents arbitrary rule, it also safeguards democracy principle, and it adheres with the constitutional compliances. Then we'll see the scope. So this come under the scope of permissible delegation, that is delegation is allowed for administrative or procedural purpose provided that it is accompanied by adequate guidelines or principle to guide the executive action. Then again, limit on delegation, clarity in delegation, then there is judicial review, public interest consideration. So this doctrine finds similarities in various jurisdictions such as in US, like the non-delegation doctrine, the UK and India, but with differences in application and emphasis. Now we'll see on the test applied by court in excessive delegation challenges. So how the court will determine that there is an excessive delegation. So there is a test has been provided that whenever assessing a statute, the court feels that there is an excessive delegation, there are specific two type of critical tests that can be held by the courts. So firstly, it is delegation of essential legislative. So the first is delegation of essential legislative function, and the second is clarity of legislative policies and principles. Now if the court scrutinize whether the delegation results in the transfer of the core legislative power that should remain within the legislature domain. Now if essential legislative function such as defining major policies or lawmaking or transferred of an administrative body, so such delegation could be considered as excessive. Then about clarity of legislative policies and principle. Now, the court evaluate whether the legislature has clearly outlined its policy objectives and guidelines principle for the executive to follow. Now, if the statute provide the executive with broad, unfettered discretion, lacking sufficient legislative guidance, it is seen as excessive delegation. Now, if this test indicates that there is an excessive delegation, that the court may order the delegation is unconstitutional. Now we'll see excessive delegation in the Indian context. So excessive delegation is a principle which is crucial to maintain the first prospect of the integrity of the legislative process and ensuring the due processes in India. It also underscored the need for legislature to delegate power with defined boundaries rather than passing an unqualified authority in executive bodies. Now, Indian courts have constantly emphasized that while delegation is permissible, but it must be within the framework established by the legislature and cannot undermine the legislature lawmaking function. The Indian approach to delegation evolved after its independence. Now, drawing upon both British and constitutional influences, historically the British legal system treated legislative delegation as essential for efficient governance. However, in India, after independence, the focus shifted to safeguarding legislative authority and preventing excessive delegation, specifically without clear guidelines and legislative oversights. So, these are some of the cases under Indian jurisprudence that is needed to be considered while discussing excessive delegation. I will see the importance of the doctrine. So the first importance is the legislature maintain its role in determining the key policy of lawmaking and its functioning. Now, executive can only exercise its power whenever necessary to implement laws within the scope and provided by the legislature. Now, third is that there is a system of check and balance preventing any branch of government from becoming too powerful and unaccountable. Now we'll see the advantages and disadvantages as well. We'll see advantages. Advantages of the doctrine of excessive delegation is firstly maintaining separation of power, then prevent arbitrary decisions making, then encouraging legislative clarity, then further there is to protect the fundamental rights, and fifth is ensuring accountability, which holds the legislative accountable for its decision and ensure transparency in delegation. Now we'll see the disadvantages. So the first disadvantages is that it limits flexibility. It also focuses that overburdening the legislature, because as this doctrine of delegated legislation is made to oversight the burden of legislature, but this restriction might lead to an overburdening legislature. Now third is increasing judicial intervention. Fourth is hinder efficient governance. Fifth is complexity in legal interpretation. If you can end it up with a short conclusion where you can define about what are the challenges in excessive delegation that we have seen as far, and how too much power delegation will lead to sufficient reason for it to be unconstitutional. So this is all about in delegated legislation. In the next part we will see the power of inclusion and exclusion and the safeguard controls and sub delegations.
So if you like this video, then please like, share and subscribe Timeless Trial so that you don't miss any latest update from our channel, and we'll keep posting the notes on the other subject also, like administrative law, company law, as possible. Thank you.